The judge, you are given here. One can even pass in class.
And not just that. Count number 2. How could he have gotten that wrong? Conflict of interest. And it does not only mislead you on that. He says that the prosecution, on behalf of the prosecution, no law has been pleaded. No evidence has been brought. I refer to Tom Chomley, case law in Kenya. I quoted Article 49(1)(h). I quoted Section 123(a). These are laws in Kenya. 123(a). These are laws in Kenya. The second question, Your Honor, my learned senior, Sharia, if I don't get that wrong, tells the court that the areas, the subject of the warrants issued on 18th of June were limited to 3, Kibomet and another one, it's on the record.
Sharia also.
Oh, Mr. Sibiu, I apologize, that's why I was not sure who's in. Your Honor, for those who have not given you a copy of that warrant, it says, and any other warrant. Let me just read that so that I get it correct, so that I don't mislead the court. The warrants have been referred to just below the areas listed.
There is and any other office, business, and residential premises wherever they may be situated within the Republic, unless we are reading different.
So that even the search in Trans Nzoia was by law, was sanctioned by law. But then there's the related question as to whether the warrants issued could also be the basis of an arrest. That is a question asked by my learned friend and teacher, Mr. Chesa. Your Honor, this is a cognizable offense. Mr. Smith taught me this way back in 2011. For cognizable offenses, you don't need a warrant. So the arrest was proper by law. So the arrest was proper. The searches were proper. The defense has attempted to repudiate the charge sheet. Although they have gone around the corners, they're not coming strongly about it. But they seem to be questioning the propriety of the charge sheet, or rather the charges. There was no attempt to invite this court under Section 895 of the Criminal Procedure Code to reject the charges. Plea was taken. As it is, the charges are proper, including the particulars. And in compliance against with Section 214 of the CPC. But there's a smaller issue about the amounts. This is related to the charge as well. That a whole governor should not have been brought before you for amounts about 1 million or 2 million. I agree with Mr. Ochieno that this court may not interpret but can apply. In the application of the constitutional provisions, Article 27, Article 4 obligates this court to ensure and promote an equal application of the law to everyone. Equal application of the law. Article 27, Article 4 of the Constitution. Before this court, Your Honor, I've never had the privilege of appearing before you. I'm sure my colleagues who have here have brought people with cases of soliciting a bribe. Some of them up to 3,000 or 5,000. They are Kenyans as well. so that the amount, the basis of the charge cannot be the basis to question whether or not the charges are proper or whether or not compelling reasons exist. Even I can confirm to this court that a factual issue, I can confirm to the court that the DPP, in fact, ascertained and satisfied himself that there were charges properly on the basis of which he could institute these proceedings before him. In respect of Article 181 and 182 of the Constitution, we are not attempting to impeach the governor. The DPP has no such powers, legally or factually. But more importantly, whether or not denial of bail would amount to removal of a governor has been answered by the Supreme Court of the land in the case of Ferdinand Waititu versus Republic.
He's raising new facts that were not part of our press to the court.
That's a question of law, Senate.
No, it never came up, Your Honor. We perhaps need a very clear ruling on that particular objection, because that never arose in our submissions.
When Dr. Amin raised Article 181 and 182 and said that removal can only be by other parties, not the DPP or this court. That's what I'm answering. And again, because Mr. Negwa did not even know that conflict of interest was count one, he may have missed this as well. I withdraw.
If you have withdrawn, I wanted to clarify that I scored with Dr. Amina saying something else. Yes. He's trying to mislead. Unfortunately, he's trying to mislead the court. Now that he has withdrawn, there is no need to clarify that point.
So, Your Honor, I further withdraw.
Differently, so now that you withdraw that point, I will not.
Most of that. I've also withdrawn the arguments on 181, so I scored it different. Your Honor, back to the question of bond as I conclude. Page 19 of the Judiciary Bail and Bond Guidelines, at the very bottom in the footnotes, refers to a case of Republic versus John Kahindi and two others, reported in the Kenya Law Report in 2010. Republic versus John Kahindi and two others, 2010 EKLR. It is at the footnotes of page 19 of the Judiciary Bail and Bond Guidelines. The import of that case, Your Honor, is that the prosecution does not need to avail an affidavit in opposition of bail. Anyone can confirm because the guidelines are available online.
The prosecution
does not need to avail an affidavit in support of an application for denial of bail. While other courts insist on it, not all courts insist on it. That's the import of that decision. It's cited at page 19 in the footnotes. The importance of that argument that you make is that even without an affidavit, compelling reasons can exist. And so that the argument by Mr. Ochieno that if certain documents were removed or expanded, then there is no basis. If we can come without an affidavit, there is still basis. There's also the argument as regards saying that we are not proved Your Honor.
we are now on the 12 minutes.
2 minutes and I'm done, Your Honor. I underestimated my abilities. I'm sorry.
You can't admit that. No, your pace, not abilities. I'm not doubting your abilities. You underestimated your pace.
Yes, yes.
Minute. You can continue, Mr. Owens.
Thank you. I was referring to, please don't just help me direct. What did I say last?
Last you were attacking the challenge by Mr. Otieno.
All right, yes, thank you very much. So Mr. Otieno was of the effect that if there is no certificate and
that was concluded.
then I can move to the next point. The other issue as regards bail, as I conclude, is that there is an admission from the defense, at least evidenced by Mr. Echesa and Dr. Haminwa. In Mr. Echesa's words, the first accused is a governor of a county, he is a deputy party leader, and he is not a lonely man. Verbatim, if I got it right. In the words of Dr. Haminwa,
I don't know whether my Honor will misquoted in my presence in terms of understanding.
you were not sure what you are objecting on. Is it point of law or what you say?
As in, you have quoted my statement in my presence. Yes. You clearly misunderstood it, and you want to go to the next person without clarifying the question.
Sorry, Your Honor, I have not interpreted what Mr. Echesa said. I have quoted it as I captured it. So the court can confirm that he said that the first accused is the governor of a county, is a deputy party leader, and is not a lonely man. I am quoting you verbatim. I may be wrong in my interpretation, but in hearing you, I can't be wrong.
Of facts.
Your Honor, I'm coming to the point of law. I'm still quoting him. You cannot be the point of law. I am coming to the point of law. Yes, Your Honor, I'm still quoting so that I come to the point of law. Dr. Haminwa, on the other hand, says that the people in the first accused area were mad yesterday as a result of his arrest. Those are two admissions as to and thirdly, I am reminded that my very good friend, senior Dr. Harold Nubi, mentioned that monkey see, monkey do, that the people have seen and are doing. The point of law we are making is that there is a likelihood of interference with witnesses. And that the influence of the first accused is admitted by his counsel on his behalf. And that it is not far-fetched that he would interfere with witnesses and investigations. Your Honor, clause 4.9 sub-clause E of the Judiciary Bail and Bond Policy Guidelines talks about likelihood.
And you also said you have to be John, because in their scheme of things it appears that the heavens only recognize John, not people. We were told that all the education we had acquired meant nothing, so that if you in God or intelligent, you are only intelligent. In Portuguese, we now